Thanks everyone for being here today. This is a webinar about privacy in the media, specifically in the context of the Broadcasting Standards Authority and its work. So I'm Stacey Wood. I'm the CE at the Broadcasting Standards Authority. I've been here since 2022. Previously worked as a journalist, an IP lawyer, and later as a general manager at Engineering New Zealand. So I'm going to give a rundown of how privacy relates to our work, how the authority applies its privacy standards to media complaints, and I'll run through what the standard is, how it's applied, and then a few recent case studies to show how it works in action. Hopefully we'll have some time for questions at the end. It just depends how fast I talk. There is a Q&A panel where you can enter questions. But the BSA is here for the public though, so we're always happy to answer questions about our work. So if you miss out on any questions or think of something later, it's not your only chance. We're always happy to be contacted. So quick rundown of what the BSA is. We are a very small independent Crown entity created under the Broadcasting Act 1989. Our jurisdiction extends to television and radio in the traditional sense. So not online streaming, not social media, linear television and radio only. So one of our big challenges at the moment is that that's becoming increasingly a less relevant way of people getting their content, their news, their media, and there's very little regulation of online spaces. So our big push at the moment is to see reform of our Act to bring us into the 21st century. But for now, we are television and radio focused only. We have a board of 4 members supported by a team of 8 staff. And our primary function is determining complaints as well as conducting research about broadcasting related issues, overseeing the development and reviewing the standards to make sure that they're still current and still relevant to community expectations. And we also do education and engagement work like seminars like this. And at the heart of all of the work that we do is the right to freedom of expression. So not just free speech, but a person's right to seek and to impart information that they choose to. And in assessing every complaint that it gets, the authority always starts with considering freedom of expression and then balances that with reasonably justified limits, because like all human rights, freedom of expression isn't absolute, and it's always subject to those reasonable limits. So privacy is one of 8 standards overseen by the BSA to help achieve our vision of freedom in broadcasting without harm. These are the others. I'm not going to discuss any of the others, but they're all interesting in their own right. The privacy standard applies to identifiable living individuals who are featured in a broadcast or who are directly affected by it. It doesn't apply to people who are deceased or to organisations. And the standard aims to respect people's wishes not to have themselves or their affairs broadcast to the public without their consent. Seeks to protect their dignity, their autonomy, their mental well-being and their reputation, and their ability to develop relationships, opinions and creativity away from the glare of publicity. However, the standard also allows broadcasters to gather, record and broadcast material where this is in the public interest. So every time the authority considers a complaint under the privacy standard, it's balancing 2 competing rights, both of them very important. So it's the right to freedom of expression and people's right to privacy. And both of these are considered pretty fundamental rights in a well-functioning democracy. But like I said earlier, they're always subject to reasonable limitations. One thing that makes the privacy standard different to the other standards in the code book is that privacy complaints can be made directly to the BSA without needing to go to the broadcaster first. And that's because privacy is recognised in the broadcasting standards as a special and an important right. The primary purpose of most of the standards that are listed here is to prevent potential harm to audiences who are watching or listening to broadcasts. But the privacy standard is different in that it protects against harm to specific people who are identified in a broadcast. And so, So a breach of this standard often means that a person or multiple people have experienced actual harm due to the broadcast, even though there might be no actual harm or potential harm to the wider audience. So it's balancing a different set of rights and principles to what the authority does with the other standards. So like I said, you can choose to make a privacy complaint directly to the BSA, or you can take it to the broadcaster first if you wish. If you're complaining about privacy and other standards, your complaint should go to the broadcaster first. But if it's just a privacy complaint, then you can cut out that step and come straight to the authority. The authority also has additional powers to award costs in respect of privacy complaints. So with all of the standards, there's a maximum of $5,000 in costs to the Crown available as a penalty. But with privacy complaints, the authority can also order the broadcaster to pay compensation to the person whose privacy has been breached, up to a maximum of $5,000 again. And that's in recognition of that fact that a breach of privacy is a harm to a specific person or people, whereas the breach of the other standards is a harm to the community at large. The slight exception to that is the fairness standard, because where there's been a breach of the fairness standard, that means a person or an organisation who's featured in a broadcast has been treated unfairly. But there's no special compensation available in those cases, which does seem slightly inconsistent with the privacy standard. And in any legislative reform, which we're very much hoping for soon, we would like to see both the cap for compensation lifted and a more flexible approach that recognises that privacy is not the only standard that can cause harm to specific individuals. So when we get a privacy complaint and when the authority comes to consider whether it's been breached, the privacy standard's been breached, there's three key considerations that they step through. So those are whether a person was in fact identifiable in the broadcast, whether they had a reasonable expectation of privacy over the private information that was disclosed, and whether the disclosure or the intrusion was highly offensive. It's not a breach of privacy if a person has given informed consent to the disclosure. And there are also cases where the significant public interest in what's been disclosed is enough to outweigh the person's right to privacy. So as with all decisions, the authority makes its determinations case by case and very much based on the particular facts and the context involved. There's almost no black and white rules about what is or isn't a breach of standards. The answer is almost always, it depends. And the lawyers in the room will be very familiar with that phrase, I'm sure. Anyone can make a complaint under the privacy standard. It does not need to be made by the person or the people whose privacy has allegedly been breached. We can and do accept complaints from members of the public who are aggrieved on someone else's behalf. And that has its own challenges sometimes, which shall be demonstrated in some of the case studies later, because can be hard to assess whether there's been informed consent, for example, if somebody's complaining on behalf of somebody else. So it's not the complainant's privacy who's been breached, it's somebody else's. We don't necessarily know if the person has consented to that. We'll come back to that later. Expectations of privacy do vary with time, with culture, with technology, and that can create some difficult boundaries. So our guidance on the standard isn't exhaustive and sometimes gets refined when it's applied to a particular case. The BSA is a tribunal. has its standards are different to the common law of privacy, the tort of privacy, the obligations under the Privacy Act. So while the authority can have regard to developments in law in those areas, and it will consider relevant precedents, it's ultimately applying a different set of standards. And so a person whose privacy has been breached in a broadcast might have a right of recourse both through the courts as well as through the broadcasting standard system, and the tests will be slightly different in each. As far as numbers go, privacy is the subject of relatively few complaints to the BSA. We had 6 complaints about privacy in the 2023-24 financial year, compared with the more frequently complained about standards like accuracy, balance, and fairness, which had 69, 62, and 45 complaints respectively. But when they do come in, they're often interesting. They're often sensitive with respect to the person whose privacy is alleged to be breached. So they can present particularly challenging and complex weighing of the different rights. So just some notes on the first consideration, which is identification of a particular person. Some of the points that go into this consideration are whether the person was identifiable beyond family and close friends who would reasonably be expected to know about the matter that was in the broadcast. It goes beyond name and face, so a person doesn't need to be named, their face doesn't need to be shown in order for them to be identifiable. It can be made, the identification can be made out by references to where they live, what they do, what sort of car they drive, for example. And in privacy complaints, a concept that often comes up is that of jigsaw identification, which is when a person can be identified through a combination of the information that's in the broadcast and other easily findable information. So if you Google someone and certain details come up, or if you Google certain details and a person's name comes up, sometimes that can be sufficient to for the person to be identifiable in the broadcast. Again, some of the case studies later will show how this works in practice. Does a person have reasonable expectation of privacy? This is the second of the 3 considerations. So a person is usually not considered to have a reasonable expectation of privacy when the broadcast relates to matters of public record, such as court cases or things that have already been in the news. They usually don't have a reasonable expectation of privacy in public places. So that's places that are accessible to or in view of the public. But there are always exceptions. Even if you're in the most public of public places, you might still have a reasonable expectation of privacy. And that can be in cases like if you're the victim of an accident, you're caught up in an emergency, if you are bereaved or dealing with a personal tragedy, if you are a vulnerable person, someone with learning difficulties or mental health issues, for example. So a person's status, not just who they are as a person, but their role can also affect this expectation. So it's generally considered that public figures, politicians, other people who seek publicity generally have a lower expectation of privacy overall. And conversely, children under 16, for example, are generally considered to have a higher expectation of privacy. And turning to the third consideration, was the disclosure or was the information disclosed highly offensive? And this is always very much a contextual and case-based case assessment. And it's not just the content, it's also the means by which it was collected. So the information itself might be on the moderate scale of offensiveness, but if it was collected in a deceptive or a dishonest way by phone hacking or other hacking or by other nefarious means, that in itself may tip the scales towards highly offensive. Got some other factors there listed there that may indicate offensiveness. Was it disclosed for the purpose of harassing someone? Would a reasonable person find it embarrassing, sensitive, or traumatic? Does it have a negative impact on the person's reputation, exploitative or gratuitous? And does it involve somebody who has made obvious efforts to protect their privacy? So I'm going to go through 4 recent privacy decisions. The BSA has upheld 7 privacy complaints in the past 5 years. These can all be found on our website along with all of the other decisions that we issue. Want to emphasize before getting into cases where there's been upholds that broadcasters do get it right in the overwhelming majority of cases. Our co-regulatory system, which means our standards are developed in consultation with broadcasters, is a successful one. One of the stats that demonstrates this pretty well, I think, is the uphold rate of complaints. In the first few years that the BSA was around in the 90s, we still got around the same amount of complaints that we do now, but the uphold rates were in the sort of 30–40% range, whereas in the last few years, they've been more around the 5–7%. So broadcasters are doing a great job, and we know that those working in news reporting are under more pressure than ever in a lot of ways and doing a really challenging job. So for the most part, they're doing it really well. Some of these cases also involve appeals to the High Court, which are pretty rare, but can occasionally result in an authority decision being overturned, which demonstrates the complexity of these complaints and getting them right. Just a note on our appeals function as well, that BSA decisions can be appealed to the High Court, but no further. So they can't be appealed on to the Court of Appeal or the Supreme Court. So let's look at some recent decisions. This is a case, I have put the wrong year in the headline there. I've just realized it should say 2020, I think. 2022, don't know how that crept in. Anyway, in 2022, there was a high-profile BSA ruling about some broadcasts by RNZ, and the broadcasts were about a child who was under the care of Oranga Tamariki, and it included, was based on some material that was stolen from the former Waikato District Health Board and released by hackers on the dark web. So the broadcasts were reporting on a situation in which the child was effectively living in a DHB hospital because Oranga Tamariki was unable to find them a placement. And the broadcasts resulted in 7 complaints to us, including from the Privacy Commissioner, Oranga Tamariki, Waikato DHB, and the Children's Rights Alliance. So it was pretty rare for a start, although not unheard of, that we get complaints from that many complainants about a single broadcast. There was a very legitimate and strong public interest in the story itself, even though the information was originally obtained and released by hackers in a pretty obviously nefarious way. You know, shining a light on this issue was seen as something that attracted a high standard of public interest and was, you know, had a legitimate goal. But despite that strong public interest and the fact that the information had been put out there by the hackers originally, the broadcaster still had obligations to the child, their family, social worker involved in the story under the privacy standard. And so the BSA ended up upholding aspects of the complaints under both the privacy and the fairness standards. It found that the child was identifiable and their privacy was breached, even though they weren't named or their face shown. And you'll remember from an earlier slide that identification doesn't have to be explicit. So the authority found that, in addition to the child themselves, the broadcast breached the privacy of the child's family, but not the social worker who was involved. So the case finding hinged. Sorry, I'm just having a computer issue. I'll be back just a sec. So the concept of jigsaw identification that I talked about earlier came into play in this case. Although the child wasn't named and their gender, ethnicity, and their age were not revealed, the authority considered there were sufficient details to enable jigsaw identification. So people who were beyond those that knew all of the circumstances that were reported on would be able to figure out who the child was if they knew some but not all of the details that were disclosed in the broadcast. And in this case, once the difficult process of reaching the privacy decisions was done, the authority had to also consider how the decision was going to be published. So with most decisions, the authority's starting position is to name complainants unless there's a genuine reason not to. For privacy complaints, particularly if the complainant is the person who alleges that their privacy has been breached, it's more likely that name suppression will be applied. And this can be the case even if the complaint's not upheld, recognising that even if the standard hasn't been breached, it might not be justified to put the complainant in the spotlight again by naming them. And in this case, the broadcast contained a lot of information that was of a sensitive nature. And in analysing the complaint and applying the privacy standard, the authority was required to discuss that information in quite a lot of detail and needed to put that information in its formal decision, but also needed to avoid repeating the harm by republishing the details. And so for that reason, the decision that was published was a summary and didn't include the section which discussed the privacy standard in full. And for the same reason, didn't include all of the extracts from the broadcast in the decision itself. So the high-level summary can be found on our website, and it does have a decent amount of detail of the analysis, just leaves out the specifics that would risk identifying the person again. And in terms of penalties, in this case, the authority ordered a statement that summarised the upheld aspects of the decision to be broadcast on RNZ, as well as $1,800 in costs to the Crown, so about a midpoint of the $5,000 maximum. So the next case I want to talk about is called HW and Sky. I find this one pretty interesting in terms of the fact scenario. And it concerns the question of when can information that was previously broadcast, so previously out in the public, become private again. So this was a case about an episode of a crime documentary series that was focused on Māori incarceration rates and looked at this issue partly through a case study on the murder of a backpacker by a teenage boy back in 2008. And the episode also spent several minutes discussing the teenager's earlier assault of the complainant, HW, which had happened a couple of weeks before he went on to murder the backpacker. And the episode included reenactments, including the reenactment of the assault. It also included photos of the complainant's injuries, which were taken in hospital after the assault. And the photos showed the complainant, who was only a teenager herself at the time, in the hospital wearing ripped and bloody clothing with obvious signs of injury. The broadcaster acknowledged from the outset that the hurt that it had been caused to the complainant, but believed that it had acted responsibly. So it noted, for example, that the privacy standard says a person will not usually have a reasonable expectation of privacy in relation to matters that are already in the public domain. And the broadcaster felt they were on pretty solid ground because there had been significant media coverage of the assault in the past, and the complainant had even spoken to media about it in the past. The photos were also arguably in the public domain. The broadcaster got them by licensing footage legitimately from another source. And the photos had been used in an episode of 60 Minutes that was broadcast back in 2009, so a year after the assault happened. And given those circumstances, the broadcaster felt that since they'd obtained the information legitimately, consent wasn't specifically required in these circumstances. So again, in this case, the authority felt that the public interest and the value in the broadcast was pretty high. It discussed an important issue, being the overrepresentation of Māori in the justice system, and it was illustrated through case studies, which can be an effective way to get a message across. It was presented in a way that would provoke thought and discussion and made a valuable contribution to understanding the justice system. So it wasn't an exploitative or a trashy show, it was a genuinely informative documentary. On the other hand, the broadcast clearly did cause actual harm to the complainant. She wasn't expecting her story or those images to be shown again, and seeing it without warning caused her distress and anxiety. She said that it caused serious emotional harm, affected her work, her mental health and home life. She said her children could have inadvertently watched the program, and that she'd had to deal with a lot of contact from people who had seen the broadcast and who hadn't previously known about the assault. And the broadcaster acknowledged this impact and that it accepted that it should have warned the complainant that the program was going to be broadcast before it went to air. Even though they took the position that it didn't breach the standard, they did take the complaint seriously. So in terms of the test for a breach of the standard in this case, the authority looked at a few different factors. In terms of identification, the first criteria, the complainant's name and photos of her were included in the broadcast, so clearly identifiable. Didn't need to spend too much time on that criteria. The key issue in this case was whether the broadcast disclosed information over which the complainant had a reasonable expectation of privacy. And so relevant factors in this assessment included whether the content could still be considered to be in the public domain, whether the content was intimate, sensitive, or traumatic in nature, whether the individual could reasonably expect the content would not be disclosed, and the nature and circumstances of the individual themselves. And in terms of previous cases, the passage of time had been highlighted in a previous version of the Code of Broadcasting Standards as being a relevant factor in assessing whether information in the public domain had become private again. That factor is not explicitly included in the current code, but it's still consistent with common law privacy principles, and so the authority still continues to consider it in these decisions. And there were three things about the broadcast that the complainant felt had breached her privacy, and that were specifically identified in her complaint. And that was the use of her story at all, the reenactments of the assault, and the broadcast of the hospital photos. So the authority didn't agree that the story of the assault could be viewed as private information, although it was obviously traumatic and happened a long time ago. The information about the assault and the related murder were still matters of public record. They were highly publicised at the time. They've been subject to ongoing media coverage, and that coverage had from time to time included comment from the complainant, including as recently as 2020. The authority also didn't agree that the reenactments, which were clearly dramatised, were private information about the complainant for the purposes of the standard. So that left them to consider whether the hospital photos of the complainant's injuries were private information that she could reasonably have expected to stay private. And in previous decisions, the authority had found that people in hospital receiving medical treatment could reasonably expect privacy, and images of their injuries were sensitive information that they had a reasonable expectation of privacy over. It had also previously found hospital images of the survivors of a fatal crash to be private information in a specific case that was despite them being available on a public Facebook page. In this case, the complainant was particularly vulnerable when the photos were taken. It was right after a serious assault. She was only a teenager. The photos showed her in a state of semi-undress, and it showed her injuries in quite a bit of detail. And so the authority found that the photos could sensibly be categorised as being intimate, sensitive, and traumatic in nature. As far as the authority could determine, the photos were originally sourced from police and had been broadcast in 2009 as part of a 60 Minutes story. And the complainant was interviewed as part of that program and was a willing and active participant at that time. Although in this case, it should be noted, the complainant said she couldn't remember watching that episode or whether the photos were broadcast in it. And, being so long ago, the authority made investigations but could find no evidence that the 60 Minutes episode had been rebroadcast since 2009. They also couldn't find anything to suggest that the hospital photos had been relicensed or otherwise publicly available since that time. So since the photos weren't publicly or easily accessible information, they weren't sort of a matter of public record in the usual sense at the time that this program was being produced. Also looking at previous cases in terms of past information becoming private again, the authority in earlier cases had found that a range of timeframes, so from 6 months to 13 months, even to 6 years to 17 years, had all been insufficient for information about previous criminal history to become private again. However, those cases concerned convicted criminal offenders rather than victims, so it was considered to be a bit of a different assessment. In another case, the authority had found that 10 years was sufficient for footage of a complainant being arrested and details of their solvent abuse to become private again. So the authority found this relatively challenging element of the complaint to decide, and there was certainly acknowledgement that the broadcaster had taken steps to ensure it was acting responsibly. However, on balance, the authority found that the sensitive and traumatic nature of the photos, the passage of time since they'd last been publicly broadcast, meant that the information had indeed become private again, and the complainant could reasonably expect that the photos wouldn't be disclosed 13 years after the fact. So having found the photos to be private information, the last limb of the privacy test requires the disclosure to be considered highly offensive to an objective, reasonable person in the complainant's position. And the authority was satisfied that this disclosure would be highly offensive, taking into account that the standard aims to protect people's dignity, autonomy, mental well-being, and the broadcast of these photos so many years after the fact and without any warning had the potential to significantly affect the complainant's mental well-being. The fact that the complainant was also extremely vulnerable at the time was highly relevant. In terms of times and places where individuals are entitled to be left alone, the authority considered that being taken to hospital in the aftermath of a traumatic event was one of those times. The nature of the photos themselves as well, so they're reasonably graphic and showing obvious signs of injury, contributed to the offensive nature. The final step is considering whether any defences are available to the broadcaster for the breach of the complainant's privacy, and it is a defence to a privacy complaint to publicly disclose matters of a legitimate public interest. As we said earlier, there was clearly a high value and public interest in this program as a whole, and the complainant's story was certainly relevant to include. But in assessing the public interest in the photos, the authority considered guidance from a previous High Court case in which the High Court had said, in assessing an asserted defence of legitimate public concern, the court will ordinarily permit a degree of journalistic latitude so as to avoid robbing the story of its attendant detail, which adds colour and conviction. So that's sort of saying the court's going to allow a certain amount of detail in a story that might not be crucially necessary to tell the facts, but adds to the illustrative nature in the telling of the story. But in the authority's view in this case, they felt the story could just as powerfully have been told without the hospital photos. There was already the reenactment, and so the photos were unnecessary to illustrate what had happened, especially given their sensitive nature. Finally, the broadcaster also argued it had informed consent from the complainant based on her previous involvement in reporting on the crime. But given that it was so long ago and there was no specific informed consent in recent years for the photos, the authority didn't accept that defence either. So the complaint was upheld, and the penalty in that case was $1,000 compensation to the complainant. Right, got 2 more cases to go through, and then hopefully we'll have a bit of time for questions at the end. This case is called Wix and TVNZ. This one was a bit more of a straightforward analysis of the privacy standard, but had some complexities around the defence of informed consent. And in this case, and part of that complexity arose because the complainant in this case appeared to be an unrelated member of the public, so not related to the person whose privacy was alleged to be breached. And the broadcast was a story reporting on boy races in a particular area of Christchurch that was said to be almost abandoned. And the item featured an interview with a woman who said she was too scared to be identified as she feared retaliation from the boy racers. So it included fairly close-up footage, including an unblurred side-on view part of her face. And so you could tell her gender, her broad demographic, the length and the colour of her hair, profile of her nose, sound of her voice, what she was wearing, her watch, a distinctive ring on her right hand, and the side of her glasses. So the complainant felt that the interviewee was able to be identified by these details and was therefore put at risk. And the broadcaster didn't find any breach of privacy because the limited information about the woman wouldn't lead to her being identified beyond family and close friends. Even if she was able to be more widely identified, she'd given informed consent about being in the item and hadn't expressed any concerns or made a complaint since the item was broadcast. And the broadcaster later clarified that the camera person who filmed the interview had said that the woman had agreed to close-ups of her hands, etc., but nothing showing her front on. So in terms of identification, the first of the 3 considerations, broadcasters need to take steps if a person doesn't want to be identified. So they need to mask a person's identity and ensure that that masking is effective. And in some cases where there's a unique combination of identifying features within the broadcast, simply masking their face could be inadequate. In this case, the combination of identifying features was enough for the interviewee to be considered identifiable beyond family and close friends. As well as the physical attributes, it also confirmed her location and the fact that she was in one of about 25 occupied houses in the area. So in other words, a very, very small community. And so it was likely that other people who knew or had dealings with her would be able to identify her from these details. And anyone wanting to find out who she was would likely be able to do so. So the next question is whether the broadcast disclosed information about which the interviewee had a reasonable expectation of privacy. This was a fairly easy one in this case, given the woman said she was too scared to be identified and feared retaliation, and had taken part on the understanding that she wouldn't be identified. The third criteria was that the disclosure would be highly offensive, and in this case, in connection with her concerns about retaliation, the information was particularly sensitive and she had a degree of vulnerability. The broadcaster said that it had a defence because the woman had given informed consent to the interview, but the authority put weight on the fact that she clearly didn't want to be identified and had participated on that condition. So the fact that she had reportedly agreed to close-ups of her hands but nothing showing her front on wasn't considered sufficient evidence that she'd consented to what was used in the item. Nor was the fact that she hadn't complained herself enough evidence that she'd consented. The authority felt that people may choose not to complain for a variety of reasons, and so given that she'd explicitly said she didn't want to be identified, the onus was on the broadcaster to ensure that she wasn't. At the time of the authority's decision, the broadcaster was able to provide a note from the woman saying that she was comfortable with the footage, but this didn't change the authority's decision that they should have ensured this before the footage went to air. But it did factor into the authority's decision not to make any orders for penalty in this case. So it was an uphold, but with no penalties. And TVNZ actually appealed this one to the High Court, and at that stage was able to provide some additional evidence, including from the journalist who did the story, as well as the head of news and an affidavit from the woman who clearly said at that stage that she was comfortable with how she was portrayed. And so in the appeal, the High Court didn't disagree with the authority's decision, but observed that if this extra evidence had been available at the authority's decision-making stage, then it may have made a different decision. So it was referred back to the authority to look at it again, and they issued a new decision accepting the defence of informed consent at that stage. And so ultimately the complaint was not upheld. It's still a good illustrative example of how identification can be a tricky concept. All right, last case, NH versus Versa radio station. This is another appeal. It's from 2022, and this one overturned one of the authority's decisions. And it's interesting because it concerns the question of whether the privacy standard can apply to false information. Can it be a breach of a person's privacy if they are identifiable, but the information that's shared about them isn't true, or it's not all true? I should note that in an appeal of a Broadcasting Standards Authority decision, the appeal is between the original complainant and the broadcaster. So the authority doesn't take an active role in the proceedings. We assist by providing any information that the court needs, but otherwise we abide by the court's decision. But appeals are pretty rare, and we haven't had many in the last few years. So this case involves a broadcast on a non-English language radio station, and it included comments that the complainant said identified his son and caused harm to his family's reputation. The broadcast discussed various issues around cultural practices and community matters, but it also made some pretty specific references to a person's drug addiction, family conflicts, business dealings, etc. So a complaint was made, and the authority dismissed it in a majority decision, which led to the appeal. So in the authority's majority decision, so 3 out of the 4 authority members concluded that the complainant's son was not identifiable beyond family and close friends, and therefore the complaint failed at the first step. The minority disagreed and said that the son was identifiable, and that some of the details in the broadcast, when combined, would enable at least some listeners to identify them. The minority felt that people could identify the complainant's son based on some of the detail in the broadcast, but if they weren't aware of the other details in the broadcast, they'd therefore be learning new information, and that could be a breach of the privacy standard. So the appeal challenged the authority's findings on identification, the application of the privacy standard, and consideration of relevant factors. And at the High Court, the Complainants' Counsel put forward some fairly ambitious arguments. So they argued for a broader interpretation of privacy rights under the standard in light of some recent developments in privacy law. They said that a breach of privacy should be found where the complainant had a reasonable expectation of privacy, rather than also requiring identification and that the disclosure be highly offensive. Now, the court concluded that this case wasn't suitable for such a significant legal reform, possibly partly because the BSA appeals process ends at the High Court, so there wasn't an opportunity for that to be tested further in the Court of Appeal or the Supreme Court. It's understandable that a court in that position might be reluctant to set any novel legal precedents. The appellant also argued that the authority had misapplied the Bill of Rights Act by prioritising freedom of expression over privacy rights. And they argued that privacy should trump freedom of expression. But the court again found that the authority did not err in this respect. It had done an appropriate balancing exercise between privacy and freedom of expression. The court also confirmed the necessity of identification for a privacy breach. Even though the person in this case wasn't identified by name, the court held that there were enough specific details in the broadcast to allow identification, particularly by those in the same community that the radio station's target audience was. So there were details like aspects of the person's appearance, their business activities, certain family matters, allegations of illicit behaviour, and the approximate audience of the broadcast was only a few hundred people, but many of them would have been in the same local community as the complainant and his son, so would be expected to be able to put those pieces together. The broadcast was found to contain sensitive information that the court believed the complainant's son had a reasonable expectation would remain private, and acknowledged the potential harm caused by the disclosure, even to a small audience. And so coming back to the false information question, the appeal raised the issue whether the privacy standard can apply to information that's not true. And the authority hadn't addressed this issue in its original decision because having held that the son wasn't identifiable, it didn't need to go to that next step. In previous decisions by the authority, it had held that the broadcast of untrue allegations could not be a breach of privacy. So the Broadcasters' Council in this case argued that was correct and that untrue allegations were better dealt with under the accuracy or fairness standards. But in this case, the court found that false disclosures can still be subject to privacy protections. It said that the majority of the authority had erred by failing to address the factual dispute over whether some of the allegations were true or not. And quoting from the High Court's decision, it said, if the broadcast included false information, it would not reasonably follow that family or close friends have knowledge of such matters. So they can't know because it's not true. It would be necessary to establish whether the false allegations had been ventilated within the family or whether they were otherwise in the public domain. If it was untrue that the complainant's son had X, Y, and Z, and those were false allegations levelled by the host, those could not be details that people who identified the son could reasonably be expected to have known. So, in the absence of any material proof and in light of the strong denial of the allegations, the privacy complaint should have been determined on the premise that those details were false, the court said. The court said it's the quality, i.e. the nature of the information rather than its truthfulness that determines whether privacy protections apply. And in the context of a broadcast that was said to have referenced both truthful and untruthful private disclosures, the court thought that it was appropriate that the false disclosures should be considered alongside the others under the privacy standard. Finally, the court assessed whether the broadcast was highly offensive to a reasonable person and concluded that it was. The nature of the information was deemed particularly sensitive and included allegations that were embarrassing and traumatic for the complainant's son. And the court found the broadcast was intended to harm the complainant's family within their community. It's exploitative in nature, and the vulnerability of the individual involved contributed to its offensiveness. And in this case, the court allowed the appeal and awarded compensation of $4,000 out of the maximum $5,000, reflecting the severity of the breach. All right, those are all the case studies. We're getting pretty close to time, so I just want to briefly acknowledge again the challenges that broadcasters face in upholding the privacy standards. So some of the factors that can make it difficult for broadcasters are a live broadcasting environment. So in situations where broadcasters are presenting on the fly, it can be hard to assess what's happening, and mistakes do happen, things slip through. And often in that case, the authority will give attention to what steps the broadcaster takes to acknowledge and make things right following a breach. Crisis reporting, for example, the earthquakes a few years ago, I've also seen issues come up in terms of privacy. And again, it comes down to the pressure that broadcasters are under, the high public interest in what's playing out, and balancing that against people's right to privacy. Social media also presents some modern challenges, even though it's been around for a while now. There still remains a question of, just because somebody's put something on their social media, does that mean that they no longer have any privacy rights in it? It's quite a different thing to share something with your family and friends on what you perceive to be a private Instagram page, for example, versus having it shown on TV and radio. And so that balancing act is different and contextual in every case, but can raise some interesting challenges. I feel like I've been talking for a long time. I hope that has been interesting and of some use to you. I'm going to stop sharing my screen now so that I can see the Q&A panel. And we've got 5 minutes for any questions. There, Liz. Okay. I have a question. Does print journalism follow the same rules and guidelines as TV and radio? Someone says they've seen names shared publicly in print that would go against TV and radio guidelines. Oh, where's the question gone? I was reading that. Here it is. Where do you draw the line as print is so intertwined in New Zealand? Yeah, so there's some interesting questions of jurisdiction because our jurisdiction is only over TV and radio. The Media Council is a industry self-regulatory body which deals with print and online journalism, but largely the standards are similar. And in the publication of somebody's name, is always contextual. So whether there's public interest, whether they're a public figure, the vulnerability, the necessity of naming them, relevance to the story. So asking where do we draw the line? It's different in every case. And there are some jurisdictional issues with having the different forms of media separated out, which we hope will be addressed in any regulatory reform, because it is hard when, for instance, RNZ may be subject to both BSA and Media Council jurisdiction with their radio and online platforms. And then there are other forms of journalists who are not regulated by anyone. Another question. How family history shows finding adoptive relatives, solving family mysteries, etc. How do you assess a situation where different relatives involved have different views and different expectations of privacy? So shows set up a situation to seem more spontaneous than they actually are. How do we deal with that? Yeah, really good question again, and always going to be highly fact specific, and depend on the context. I can imagine it must be difficult being a producer of one of those shows and having to get consent from a bunch of different people with different expectations around what's going to be shared. I don't know the answer is the short answer. Well, this is one I can answer. Can I talk about the makeup of the authority? Are members required to have a legal or media background, etc.? So the Act requires that our chair is a lawyer with a certain amount of years of experience. I can't remember exactly how many. Other specifications are one of our members is appointed in consultation with community groups, and another of our members must be appointed in consultation with the industry, so with the broadcasters who are regulated. But they don't all have to be lawyers. At the moment, 3 of our 4 are lawyers. So there are variety of requirements, but we do try to have a diversity of experience on the board, so people with industry experience, people with legal experience, to make sure that we're sort of, with only 4 people on the board, we're as representative as we can be of the community. We have only got 2 more minutes to go, so I might just hold off on answering any more questions in favour of repeating again that we're a public organisation. We're here to serve you. If you have questions, we're happy to answer them outside of this webinar. So you can find our website at bsa.govt.nz. That has contact details. It also has guidance and all of our previous decisions on it. So if you can't find the answers to your questions there, let us know and we'll help you out. But thanks very much for coming today. Really enjoyed it, and I hope that it has been helpful.